Your Honor, you are muted. We can't hear you. Your Honor, you are muted. We can't hear you. Your Honor, you are muted. We can't hear you.
I'm muted on purpose. Thank you.
Thank you.
All right, everyone can be seated. Thank you. Welcome back, ladies and gentlemen of the jury. It's 9:14. As predicted, we had a busy morning, and I'm sorry we're a little bit late, but we are going to get started in City versus Alicia Sale 5104-1002. Hope everyone had a nice evening and you're all situated here and ready to go. I am going to read the instructions, and my clerk is going to bring you a copy of the instructions. You're welcome to read along, or you can just listen. Either way, you're going to have those instructions to review when you're back in the jury room deliberating. So there are 19 instructions. It's probably going to take me 20 minutes to get through them. And so be patient, please. And then we will hear from the attorneys as far as their closing arguments go. Instruction number 1, this is like the longest instruction that we have. It's your duty to decide the facts in the case based upon the evidence presented to you during this trial. It's also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way, decide the case. Please keep in mind that a charge is only an accusation. The filing of the charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses, any stipulations, and the exhibits that I have admitted during trial. If evidence was not admitted or was stricken from the record, then you're not to consider it in reaching your verdict. I don't believe there were any exhibits that were marked and not admitted. The ones that were admitted will go to the jury room with you. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings about evidence. If I have ruled that any evidence is inadmissible, or if I've asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to that proposition. Each party is entitled to the benefit of all the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You're also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider the following: the opportunity of the witness to observe or know the things that he or she testified about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have demonstrated, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It's important for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits, and the law is contained in my instructions to you. So, you must disregard any remark, statement, or argument that's not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you, and you should not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence, and I have not intentionally done this. But if it appears to you that I have indicated my personal opinion in any way, either during trial or in the giving of these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss instructions. During deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court, and you must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. And I didn't mention earlier today, but we are on YouTube, so we're open to the public. The public can be watching these proceedings, just a reminder. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. The defendants entered a plea of not guilty. That plea puts in issue every element of each crime charged. The city is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, then you're satisfied beyond a reasonable doubt. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in the case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 5. A separate crime is charged in each count. You must decide each count separately. Your verdict on one count should not control your verdict on any other count. Instruction number 6. You may give such weight and credibility to any alleged out-of-court statement of the defendant as you see fit, taking into consideration the surrounding circumstances. Instruction number 7. A person commits the crime of disorderly conduct when he or she intentionally obstructs vehicular or pedestrian traffic without lawful authority. Instruction number 8. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 9. To convict the defendant of the crime of disorderly conduct, each of the following elements of the crime must be proved beyond a reasonable doubt. Number 1, that on or about November 1st, 2019, the defendant intentionally obstructed vehicular or pedestrian traffic without lawful authority, and that this act occurred in the city of Bremerton. I'm not sure why it says that any of these acts occurred in the city of Bremerton. It should be that occurred in the city of Bremerton. If you find from the evidence that each of the elements have been proved beyond a reasonable doubt, then it's your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it's your duty to return a verdict of not guilty. Instruction number 10. A person commits the crime of resisting arrest when he or she intentionally prevents or attempts to prevent a peace officer from lawfully arresting him or her. Instruction number 11. To convict the defendant of the crime of resisting arrest, each of the following elements of the crime must be proved beyond a reasonable doubt. Number 1, that on or about November 1st, 2019, the defendant prevented or attempted to prevent a peace officer from arresting her. Instruction number 2, that the defendant acted intentionally. Instruction number 3, sorry, not instruction. Number 2, that the defendant acted intentionally. Number 3, that the arrest or attempt to arrest was lawful. And number 4, that all these acts occurred in the city of Bremerton. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 12. An arrest is lawful if the arresting officer had probable cause to believe that the person arrested had committed the crime of disorderly conduct in the officer's presence. Probable cause means facts that would cause a reasonably cautious officer to believe that the person had committed that crime. In determining whether the facts known to the officer justified this belief, you may take into account the officer's experience and expertise. Instruction number 13. A person commits the crime of harassment when he or she, without lawful authority, knowingly threatens to cause physical damage to another person's property, and when he or she, by words or conduct, places the person threatened in reasonable fear that the threat would be carried out. Instruction number 14. Threat means to communicate, directly or indirectly, the intent to cause physical damage to the property of a person other than her own. To be a threat, a statement or act must occur in a context or under such circumstances where a reasonable person in the position of the speaker would foresee that the statement or act would be interpreted as a serious expression of intention to carry out the threat rather than as something said in jest, idle talk, or political argument. Instruction number 15. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of the fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 16. To convict the defendant of the crime of harassment, each of the following four elements of the crime must be proved beyond a reasonable doubt. Number one, that on or about November 1st, 2019, the defendant knowingly threatened to cause physical damage to the property of the 76 gas station at 2550 Burwell Street in Bremerton. Two, that the words or conduct of the defendant placed Elisa Bell in reasonable fear that the threat would be carried out. Three, that the defendant acted without lawful authority. And four, that the threat was made or received in the city of Bremerton. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 17. A person commits a crime of bail jumping when he or she fails to appear as required after having been released by court order or admitted to bail with knowledge of the requirement of a subsequent personal appearance before a court. Instruction number 18. To convict the defendant of the crime of bail jumping, each of the following elements of the crime must be proved beyond a reasonable doubt. Number one, that on or about February 21st, 2021, it should be 2020. So if you want to go ahead and change that, I'm changing it now. That the defendant failed to appear before a court. And two, that the defendant was charged with disorderly conduct, resisting arrest and harassment, a gross misdemeanor or misdemeanor. And three, that the defendant had been released by court order with knowledge of the requirement of a subsequent personal appearance before that court. And four, that these acts occurred in the city of Bremerton. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it's your duty to return a verdict of guilty. On the other hand, if after weighing all the evidence you have a reasonable doubt as to any one of these elements, then it's your duty to return a verdict of not guilty. Instruction number 19. This is the last instruction I'm going to read to you. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has had a chance to be heard or has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You are officers of this court and must evaluate the evidence with an open mind, free of bias and prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of your fellow jurors. Do not assume that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you've been unable to answer, write the question out simply and clearly. For this purpose, there's a form which each of you have. It's the last page of your packet that we handed to you. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff, and then I'll confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted into evidence, these instructions, and a verdict form for recording your verdict. You must fill in the blank provided in the verdict form, the words "not guilty" or the word "guilty" according to the decision that you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror must sign the verdict form and notify the bailiff, and the bailiff will bring you into court to declare your verdict. So, ladies and gentlemen, at this time, I'm going to ask that you give your full attention to the closing argument of Mr. Hersey on behalf of the city. Do you want to take a mic over there, or are you going to speak loud enough so that mic can pick up?
Well, I've been going without a mic over here the whole time. Has it been okay, audio-wise?
Well, I don't know, because we haven't listened to it.
Yeah, good point.
So you better hope so.
I'll talk really loud.
Good,
Okay.
that'll work. Thank you.
All right. If anyone can't hear me, as always, please just raise your hand. Good morning, everyone. Thank you all for coming back. Thank you for your time and your attention. I sincerely appreciate it. Just like I said at the beginning of jury selection, this is an incredibly important civic responsibility that you're all taking part in. It's an inconvenience to you at the very least. You all have things you need to be doing. You all have busy lives. But what you're participating in today and yesterday really ensures that everyone gets a fair trial. So I do want to thank you for your time and your attention. I can tell you all been busy taking notes and paying attention. So thank you sincerely. So I'll try to keep this pretty brief. The facts in this case are simple and the evidence is overwhelming. So let's just dive right into instruction number 16. I'm going to go in chronological order of the events that happened, which is not exactly in order of the instructions. So feel free to refer to instruction number 16 if you'd like. I know it's a lot of paper to flip through. So let's just go over what you need to find in order to return a verdict of guilty. That on or about November 1st, 2019, the defendant knowingly threatened to cause physical damage to the property of the 76 gas station there on Burwell Street. That those words or conduct placed Elisa Bell, the store clerk for the store, in reasonable fear that the threat would be carried out, that she acted without lawful, the defendant acted without lawful authority, and that the threat was made or received in the city of Bremerton. We can start with some of the easy ones first. The fourth element, you heard that the Burwell gas station is in the city of Bremerton. You'll get to see exhibit number 2 there, which shows a map. You'll be able to see exactly where it is. But, that one's pretty easy. We also have to prove that the defendant acted knowingly. So you can reference instruction number 15. It's a little bit wordy, but it defines what it means to act knowingly. Here, and remember, this is going to be a point of contention, I think, with Mr. Brad when he stands up in a moment. Nowhere in these instructions will you get an instruction that says being frantic or stressed out or having a really bad day means that you're not acting knowingly or acting intentionally. Here, even by the defendant's own testimony, everything she did with a plan. She was fully conscious of what she was doing. She said she woke up from a nap. She said her daughter was gone. She said she walked over to her neighbor's house with this plan to call 911. She had a plan to do this, a plan to do that. Maybe the plan didn't make a lot of sense. Maybe the plan wasn't all that rational in retrospect. But nowhere in these jury instructions are you going to see that someone under stress or in a state of personal crisis is absolved from, I guess, breaking the law. So then going to threats. That's one of the other elements we have to prove, that Elisa Bell was placed in reasonable fear that the threat would be carried out. Remember, instruction number 14 tells you what a threat is, right? You're not going to prosecute someone just for saying, oh, I could kill you right now. I'm sure everyone said this at some point in their life. That's not really a threat. It has to be more than idle talk or jest or just joking around. And you heard the calls, you heard her state and where she was at mentally and what emotional state she was in when she barged into that gas station. You heard her screaming on the calls. You heard that she walked over to that little newspaper stand and started rocking that back and forth. And she threatened to break out the windows. Maybe that by itself isn't enough, just a person blowing off steam saying, I'll break out your windows. But then when she comes back with the cinder block and gestures towards the window, at that point, it's pretty reasonable to think, whoa, I think Miss Bell on the call says, you better get here fast or something to that effect, because please get over here. She's now freaking out and actually threatening to break the windows. So at this point, that's a pretty reasonable fear to be placed in and pretty reasonable to think that she would carry that out. So then moving to disorderly conduct, that's instruction number 9. Going over what it means to, what you'll have to find to convict there. That the defendant the defendant intentionally obstructed vehicular or pedestrian traffic without lawful authority, and that this act occurred in the city of Bremerton. So obviously the second prong there is easy to prove. You heard from Officer Prowse, who told you this happened essentially almost right across from the Bremerton Police Department within the city limits. Now, with respect to intentional, you can see jury instruction number 8 actually defines what it means to act intentionally. That's pretty cut and dry there. The testimony you heard was that she was actually walking in the middle of the three-lane road or state highway. I think it was 304, also known as Burwell. And Officer Prowse noted that she was walking east. She wasn't crossing the street. She wasn't going diagonally. She was walking essentially just in the eastbound lane with a full semi-truck behind her, another car behind that, coming to a complete stop. And then the westbound lanes, traffic slowed down to make sure they didn't hit her as well. And remember, the judge instructed you in instruction number 1 that you members of the jury, you're the sole judges of credibility of each witness as they testify. So you get to decide whether the testimony is credible or not. Doesn't mean all testimony is weighted equally. You get to analyze, listen to them, you observe the testimony. So you can assess the credibility of Officer Prowse and, of course, the defendant. Here, let's think about their very conflicting testimony. Ms. Bell testified that she was walking down the sidewalk, and then she crossed over, not a 90-degree angle, but crossed over diagonally and looked to make sure there wasn't cars. But even she admitted she got honked at. Remember, cars were slowed down to a complete stop, one of them being a semi-truck. Think about how long it would take for 2 cars, including a semi, to come to a complete stop. This wasn't just a momentary crossing the street. This wasn't jaywalking. This was actually walking, yelling in the middle of the road at 11:30 at night, very dangerous, and walking straight eastbound. And I believe Mr. Brad would argue that, well, it only saw for a few seconds. Well, that's kind of all it took, because you see a person walking straight eastbound in the middle of the eastbound lanes, blocking traffic, waving your arms, seems to be yelling, I think he testified to. And she only hustled across the street once the emergency lights flashed, and she would have seen those. So now moving on to resisting arrest. This is instruction number 11. To convict, again, going back to the easy part, the same location in the city of Bremerton. we have to also prove that the arrest was lawful. So looking at instruction number 12, an arrest is lawful if the arresting officer had probable cause to believe that person arrested had committed the crime of disorderly conduct in the officer's presence. Obviously, we just went over that. Probable cause means facts that would cause a reasonably cautious officer to believe that the person had committed that crime. In determining whether the facts known to the officer justify this belief, you may take into account the officer's experience and expertise. So here, pretty simple. This is the same woman he had really just dealt with about like 20 minutes later, and he saw her walking in the middle of the street. It wasn't looking like she was walking and just jaywalking or crossing the street. She was walking eastbound, blocking traffic entirely. So at that point, he had probable cause to arrest her because it was a misdemeanor, it was committed in his presence. So at that point, he walked over and he told her verbally, "You are under arrest." And he then proceeded to again grab her by the left arm or forearm or wrist and try to put her in wrist restraints again as he testified for not only her safety, but for his safety to make sure that didn't lunge out and attack or anything like that and could be safely taken into custody. And again, going back, we also have to prove that it was intentional. By the defendant's own testimony, she admits and confirms that she heard him tell her she was under arrest, right? But according to the defendant, it was essentially smooth sailing. It was, "You're under arrest," and then she said, she did this, and that was the end of it. But remember, you can use your own experience and judging and assessing the credibility here. I mean, if that was the case, that it was smooth sailing, that it was just a simple arrest and there was no resisting whatsoever, ask yourself this: why did it take so long? Why did he have to try to wrestle her and move her actually 15 feet to another location to prop her in between his patrol car and his body? And then I think he demonstrated with his hip that he had to do this to make sure she didn't wiggle away while holding one arm, while having to use an air hold rather than take her to the asphalt ground and hurt her. It's not pretty, but this is the reality of what he had to do to put her under arrest, which was exacerbated by the fact that she had this very puffy jacket, which made it difficult to put the wrist restraints on. You know, if what Ms. Sale testified to was true, why would he have to call for backup to arrest a woman who's 5'5" and very skinny? I mean, this is an officer, I think he's testified with 27 years of experience. Frankly, her story just doesn't add up. So then moving to the bail jump, that's instruction number 16, to convict the defendant, or excuse me, I apologize, not number 16, number 18. To convict the defendant, the crime of bail jumping, each element must be proved beyond reasonable doubt. Again, there was a typo there in that first element. Should be February 21st, 2020. We don't prosecute future crimes here in Bremerton. This is a minority report. Sorry about that. I think I just hit a 1 instead of a 0. But anyway, so it's 2020. The defendant was charged with disorderly conduct. You'll get to see, we went over all those court certified documents. You'll get to go back and look at them in the jury room. You also get to listen to the 911 calls. But you'll get to see those criminal complaints that have been filed at the time that she was well aware of. She had been released by the court. You'll get to see the order on pretrial conference that Ms. Hunt told you about, where when you are at a pretrial hearing, you set a case for trial, you fill out this form, it has the future court dates, and it signs. The defendant's given notice in bold that if you don't show up for these mandatory court appearances, a warrant will be issued for your arrest. You'll also get to see the signature. She signed there at the bottom. It was served on her, and you'll also get to see her driver's license, which has her signature on it. And you can compare the driver's license signature to the signature on there. It should also be noted that you didn't hear any testimony at all or any evidence whatsoever contesting the bail jumping charge. Now, remember the members of the jury, there's no question that this was a bad night for Ms. Sale. There's no question that maybe we should have sympathy for her. She was stressed out, and who wouldn't be? But remember, being stressed out, being in this position, it doesn't give people free passes to commit crimes, to threaten gas station employees, to walk in the middle of the road and risk causing an accident or hurting yourself or others, to resist arrest and not to skip court. And remember, members of the jury, you also were instructed that you have nothing to do whatever with punishment if a violation of the law has been found. Your role is simple as officers of the court, to be fact finders, to analyze the evidence that was put before you, to look at the exhibits, remember the testimony, and decide whether each element of each crime has been proven beyond a reasonable doubt. Members of the jury, the facts in this case are simple and the evidence is overwhelming. I'm asking you to return verdicts of guilty on all 4 counts. Thank you.
Thank you, Mr. Hersey. Ladies and gentlemen, please give your full attention to the closing argument. Mr. Bratt on behalf of Ms. Sale.
Good morning. Fortunately, the sun came out. It's a little better day than they had anticipated on the weather report. So we don't want you to miss too much of it. You know, life isn't an exact science. Life is variable. Life is things change and perceptions of what's going on may be different between various people. In this case, we have a mother who expected her daughter to be home from soccer practice. She had laid down, took a little nap. As she testified, she'd be awakened by her daughter when she got home. And then the family life would continue, eating, etc. She woke up, if I'm not mistaken, about 10:30. You can review your notes. But she discovered her daughter wasn't home. And there's no calls because she didn't have a telephone. Nobody has come by. And her 13-year-old daughter is missing. She looks in the house. She's not there. We can imagine. We know what kind of terror, what kind of stress, what kind of, my God, where's my daughter, goes through her mind. I think any reasonable mother would. Obviously, some wouldn't, but in this case, she was very concerned. She had seen, she had heard, she had read about situations where 13-year-old daughters go missing. Be it from their bedroom at night by somebody pulling them out a window, from being kidnapped, walking home. She's read this, she's heard it, she knows it happens. And she immediately leaves, goes to the neighbors, frantic. I need a telephone. I need to call about my daughter. I need to call the police, have them help me find her. She is concerned about her daughter. Now the neighbor, for whatever reason, wouldn't let her use the phone. She's on North Montgomery. She walks southbound, gets down to the 76 station, goes in and asks to use the phone. And Ms. Bell was very kind, helped her. Here's the phone, I'll dial it, but you have to speak. That seems reasonable. And she's on the phone to 911. And she's saying, my daughter's missing, I gotta have somebody here, I need the police, my daughter. My daughter. And what does she get? Can you give us your full name? Well, what's your location, et cetera, you can hear the tape. You heard it. Instead of being concerned about the daughter, the 911 operator is more concerned about your name and location at that moment instead of listening. Listen to this frantic mother about what's the problem. You can find out names, etc. later, but at least listen to somebody. She was crying out to the police. Please listen to me. And it fell on a deaf ear. So out of her frustration, she hung up, walked out, hoping that they would possibly send an officer to that location. If you hang up a 911 call, usually an officer will appear wanting to know why a 911 call was terminated. But she waits. And she waits. And true, she was outside the store and possibly even in the store a bit, yelling about her daughter. Nobody's helping me. Please, somebody help me with my daughter. She's outside the store. She does that as well. She's pacing back and forth, frantic. Even the officer has to say she was in crisis. He's a crisis intervention specialist. He testified to that on the stand. Officer Prowse, very fine gentleman. But she's pacing back and forth, screaming, anybody help me. Officer Prowse arrives. Prior to his arrival, she was a piece of concrete or something. I couldn't quite figure out what it was. Well, one thing was a cinder block, and that to me is one thing, and a piece of concrete's something else, but she doesn't throw it through the window. She just has it and throws it down to the side. In what? A cry for help. Somebody pay attention to me, please. I am so concerned about my daughter. And nobody helps me. Even when Officer Krause shows up. Remember, the crisis intervention specialist. What does he do? Does he try to help her? Does he use his expertise in crisis intervention? No. He kind of fluffs her off. Quiet down, quiet down, quiet down. Instead of saying, how can I help you? What can I do for you? It's supposed to be serve and protect, but there was no service here. It was quiet down, quiet down. Don't be so ridiculous.
Objection, facts not in evidence.
Jury will decide what facts are in evidence. Sustain, or overrule the objection. Go ahead.
That's a great trick. He gets me off what I was speaking about.
Objection referring to an objection as a trick.
Sustained.
The officer doesn't help her. And we would expect, I would think, more out of a crisis intervention specialist than merely fluffing it off. And she again receives no help. She's frantic. She's in crisis. She travels eastbound. I guess eastbound would be that way. She travels eastbound on Burwell, on the north side of the street, on the sidewalk, all the way to the police department, or almost to the police department on Burwell. Burwell and Chester. And she starts getting close. She decides to cross the street, so she's on the same side as the police department. She doesn't go in a crosswalk. She crosses diagonally. And there's traffic, so she stops in the line, traffic lane lines. I want to cross, but I'm not going to walk in front of you. And that's when the officer pulls up, and then on Officer Prowse, his testimony, it was just a few seconds from the time I pulled up and she was over at my car. Just a few seconds from when he saw her till she was at the car, or on the sidewalk on the south side, speaking with Officer Prowse again. Again, she's there near the police department, seeking help. She's frantic. And she gets help this time. This solves her problem of finding her daughter. You're under arrest. Don't have to put up with it anymore. That seems like a crisis intervention specialist to me. Her coat is long. Comes down across her wrist into her hands, or maybe fully covers her hands. I couldn't quite tell from the testimony. It isn't she pulls them down. They're just there. She puts her hands behind her back. He can't handcuff her because the coat's in the way. And she's still trying to talk. Help. I need help finding my daughter. She turns, trying to speak to him, which is a natural reaction. You try to speak to somebody face to face. This is what she does. And because she's trying to speak with him further, she's arrested also for resisting arrest because her coat's too long on her hands. Another officer is called, yes. I call that testimony with her name, I call her Officer M, because I can't pronounce the name. A female officer. Of course. You're going to search the defendant. You have to have a female officer. So of course another officer was called. Counsel has spoken about knowledge, knowingly, intentional. And says there's no instruction about frantic, stress, crisis. No, there isn't. Why? Because this is the province of the jury. You look at the facts and you say, if someone is that frantic, that much in crisis, do they really have this knowledge? Do they really have the intent? And this is for you to determine from the facts as to whether you believe that she had knowledge, that she had intent or intentional or intentionally, knowingly. And I'm not going to tell you how to decide that. That's your job. Based on the facts of a frantic mother searching for her 13-year-old daughter at 11:30 at night in Bremerton on Burwell, doesn't know where she is. And if you'll recall, nobody would take her to her mother's house to see if she was there. How easy could that have been done? By the crisis intervention specialist who is here to serve and protect. This is why we have juries. There's a difference of opinion as to what the facts show. The defendant has one opinion, the prosecution has another. And we leave it to the jury, 6 honest people of our community, to evaluate the whole thing, the big picture, as they say, and determine, in our opinion, that the defendant is not guilty of harassment. She's not guilty of obstructing. The cars may have slowed down, but I'm sure most of us have seen people jaywalking in the street and stop and let cars go by and continue on their way. And she is not guilty of resisting arrest. She was merely trying to speak. She didn't run off down the street. She didn't try to get away. Now the last matter, bail term. There was testimony by Ms. Hunt. My client did not contest that testimony. She knew she had signed to be here, and she didn't appear on the day in question in February. I believe it was the 21st. And yes, she knew she was supposed to be in court. She signed the document. Why she didn't show up, we don't know. We do know she wasn't in the morgue. But whatever else reason, really wasn't presented. Because she understands. If you don't show up for court, even though it's called bail jumping, the misnomer to be best, you don't have to be on bail. You can be released on your own recognizance. But if you don't show up for court, then and you have notice of the hearing date, you're more likely than not probably consider a bail jump. She isn't contesting that which she did. She is contesting how the facts were viewed on November 1st, 2019. And I want to make sure, and this is real quick, I want to make sure that you don't blame our esteemed prosecutor for placing the date 2021. I had reviewed that instruction as well and didn't catch it either. It's just a typographical error, so there should be no weight on that. It was actually November 1st, 2020, I believe, if that's what he's referring to. So that's the case of the defendant. And we're asking for not guilty pleas, except for the bail. Thank you.
Thank you, Mr. Bratt. Mr. Hersey, any rebuttal?
Yes, Your Honor. Thank you.
Please give your full attention to Mr. Hersey's rebuttal argument, ladies and gentlemen.
Mr. Bratt just argued that life isn't an exact science. I think we'd all agree with that. The facts here are really pretty simple and the evidence is overwhelming. Now, frame this as a mother who woke up and expected her daughter to be there. Remember her testimony yesterday and her own call on November 1st, 2019 were wildly different. I'm gonna go ahead and play that for you.
It's at 911, you're putting a life-threatening emergency.
I need 911 here. I'm at a gas station. I do not know where. At the 76 station off of Burwell. I've been trying to call the cops since yesterday afternoon for my 13-year-old daughter, and nobody has helped me.
Okay, what's going on with your 13-year-old daughter?
My 13-year-old daughter is gone. My mom knew it. My mom did not answer the phone. She came and picked her up when I told her no. I went to the school to try to find her. She was not there. And then I just woke up from a nap, and she's still not home.
Okay, you're reporting her as a runaway?
No, she's missing.
I don't think she was
my mom came and got her. And you can't hear me now because I need a ride because I cannot walk back to my mom.
When's the last time you saw your daughter?
Oh, at my house when I told her she couldn't leave, and then when I got back with my car, my mom wrote a note saying she took her anyway.
And when was that?
At like 1:30 this afternoon. And then I went to my mom's, and then she refused to answer the door, so I called a policeman there to go check on her. I don't know if it ever was, and I still haven't heard nothing about my daughter.
Okay,
So you guys are God stay on hope that she's okay.
let me ask you some questions. When you last saw
No,
your daughter,
be here for my daughter, please.
what is your address where your daughter went missing from?
So there's a lot to unpack there in just a minute and 27 seconds. In the call, she says her daughter's been missing since yesterday afternoon. When she testified, she said she took a nap around, I think it was 6 p.m. or 8 p.m. and woke up around 10:30. And she was pretty sure she saw her earlier in the day, but she really had no idea. So, I mean, we don't even know how long her daughter was missing, and just complete inconsistencies there about, an entire additional 24 hours. Or was it just when she woke up from her nap that her daughter was missing? Doesn't make any sense there. She also testified she has no car or no vehicle. And then in the 911 call, she says she came back with her car, drove over to her mother's house. Keep in mind, she says her mom came and got her. I don't know if it was a note or she just remembered her mom coming and picking up her daughter at some point. Now, that's perhaps one of the most shocking inconsistencies because she testified she has no idea where she is. And then she also testified that her mom lives up on Highland Avenue and she's walked to her mom's house before and it takes about 30 minutes to get there. Now, keep this in mind, you wake up at 10:30, all of a sudden your daughter's not there. Where could she be? Oh yeah, my mom came and picked her up, but she should be home. She says she doesn't have a car yesterday, but in the 911 call, she said she had a car. I don't know, but even without a car, she said it takes about 30 minutes to walk there. So instead of saying, okay, my mom came and picked her up, I'm gonna go walk over to Highland and get her, she goes to a neighbor's house and then a gas station and then walks around Burwell, walking in the middle of the street, trying to get someone to help her, instead of just doing the very simple thing of going there. When you compare that call to what she testified to, there's so many inconsistencies that the jury should be taking into consideration and evaluating her credibility. Now, Mr. Brad also suggested that she was frustrated because the 911 call operator wasn't helping her. This call is 1 minute and 27 seconds. She hung up in the middle of the most basic questions. Where was your daughter last? So they have any idea of who this person is, how they can help. Instead, she just says, get here now. Okay? Mr. Brad characterized this as a cry for help. You know how you ask for help? You call 911, you answer the very basic questions, you talk to an officer without storming off, you answer those very basic questions without yelling and screaming at people, and then leaving on your own volition. Mr. Brad said the officer told her to stop being so ridiculous. That wasn't even close to testify to. You can reference your own notes. He also suggested that he didn't use his training in crisis intervention. and that's also not in evidence. He testified to the very opposite of that. You've heard no evidence to suggest that he didn't do that. In fact, he testified from his training experience. He tried to get her to calm down, tried to de-escalate, tried to ask very basic questions so we could figure out what was going on. Remember, at this point, Officer Kraus got to the gas station only having that minute and 27 seconds of information, and plus Lisa Bell's call to try to figure out what's going on. All he knows at this point is a woman was at the gas station, kind of freaking out and threatening employees. He needs to get over there. So he gets over there, starts asking questions. He described it as a very short interaction when she then stormed off again on her own. And during that whole interaction, he's trying to get her to calm down, trying to figure out what was going on. Now going to the disorderly conduct. Mr. Bratt said, well, it was just a few seconds, and that's correct. That's what the officer testified to. That's how long he saw her walking eastbound in the road. That's not how long she was there. And how can we determine that? The traffic was already stopped. Think about from your own training experience how long it takes for a semi to come to a complete stop. Think about how long it would take for another vehicle to stop behind that. Think about how long it would take for the entire westbound lanes to be slowed down with traffic. Remember, this is just when he saw her. He saw her for a few seconds, and when he saw this happening where she was walking eastbound, not diagonally, not across the street, eastbound, intentionally obstructing traffic, then he hit the lights, and that's when she hurried over because she knew she shouldn't be in the middle of the road obstructing traffic. Interestingly, Mr. Bratt says that when she was being arrested, she turned around. Her own testimony was not that. Her testimony was that she stayed like this and was simply placed in handcuffs. And that was the end of the story. So which one is it? Did she turn around or not? She wasn't arrested for resisting because her coat was too long either. She was arrested because she was twisting and trying to pull away and shouting and making it exceedingly difficult to follow the simple commands saying you're under arrest, please stop pulling away, please stop twisting. And an additional officer was not called because she's a female. That wasn't the testimony you heard either. She was called because Ms. Sale was resisting. He needed help to help contain her because of the difficulty of getting her under control. It was only after he moved her 15 feet towards the car and used his hip to press her against and used one hand there that he could get it done on his own accord, just as the other officer arrived. It had nothing to do with her being female at all. And Mr. Bratt also asserts that being in a crisis prevents intent and knowledge from being formed. By her own admission, she knowingly picked up the drink. By her own admission, she had a plan to do all of these things, to go from location to location to location to seek help. She was acting intentionally. She was acting knowingly. She knew what she was doing this entire night. Was it rational? No. But she knew what she was doing. Mr. Bratt also seems to suggest that the officer didn't do his job as a crisis intervention specialist, as he has deemed him. He says, how easy could it have been to take her to her mother's house? I'll tell you, it could have been very easy. You know what would have made it easy? If she gave her mother's address, if she stopped yelling at the officer, stopped accusing him, if she answered any one of his many simple questions. What's your name? Remember, he asked her. I asked him, did you even get to find out her name? And he said, no, she was just yelling at her the whole time. You can't help anyone unless you find out who they are. You can't take anyone to a location unless you know that location. You can't call a number unless they give you a number to call. This is a bit of a two-way street, just like Burwell. At a certain point, you have to give some basic information so the officer can be in a position to help her. He wanted to help her. She didn't willfully walk away on her own volition. If she didn't get frustrated and say, you know what, screw you, I'm out of here, he could have helped her. He wanted to. And this is the exact same way that she hung up on the operator. If she took the time to answer these basic questions, the police could have been in a position to help her, find out if her daughter was even missing, or if her daughter was just picked up as her mom told her. And maybe she forgot. Maybe something else was going on. Remember, members of the jury, you are officers of the court. Your role is not to consider punishment or anything of that nature. It's to determine the facts of this case, determine if the city has proven the elements of each individual count beyond a reasonable doubt. Those elements have been proven. It is your duty to return verdicts. I ask that you do that. Thank you.
Thank you, Mr. Hersey. Ladies and gentlemen, I'm going to collect the exhibits. There's one here. My clerk Cindy will take you back to the deliberation room and you can select a presiding juror and begin your deliberations. Here you go. Those are all the exhibits except the recordings. Who's in charge of getting in the recordings? Yeah, now? What?
Yes, she was waiting for me to let.
You want me to let her know?
Sure.
So the original bailiff that you met at the other building is gonna bring up a laptop for you if you want to play the 911 tapes. So if you'll go with Cindy, please. Thank you. Yeah, so they're ready for the recordings and the laptop. The jury's in the deliberation room now.
You have to be within 10 minutes of the court. Okay. You can go wherever you want.
Right, it's only two.
You're within 10 minutes of the courthouse.
Yeah, that's the first one. And then the second one was the one that they had the blackouts.
Oh, but I can't stay at the
So
courthouse?
we're
You
recording.
can. If you want to stay here, you can stay here. It'll be downstairs. Or you can go someplace if you've got a phone now.
Okay, why don't you close the door?
Yeah, it's
You
only
go
10
close
minutes
that
away.
door.
That's like 7-Eleven.
Okay, I'm gonna put you on speakerphone,
So what
Don.
I'm saying is,
I'm actually on
you can
Zoom.
call yourself.
We can just hang up. I can talk to you there.
Well, no, this needs to be on the record.
Right, but I can unmute myself on Zoom and talk to you on
Yeah,
there.
I'll be staying here.
Me, I'm gonna go back to my office.
Well, hang on. We have an issue. So you have to be on, I mean, there's no reason you can't be on Zoom. I mean, we're still in court. So I'm asking, Cindy told us that Dawn had the recordings ready to go. Dawn apparently doesn't have the recordings ready to go. So will you explain for the record what the problem is with the recordings?
Yes, I received an email from Mr. Hursley that had 2 911 calls. And neither of those calls, I believe, are the ones that just got played. So I want to make sure that I have the right call to send to the jury.
I already sent that one earlier. I can resend Miss Sales' call. The only ones I sent the only call I sent was the call from the clerk that I had spliced overnight to cut out that portion. So what I'll do is, Dawn, I can email that to you right now.
So apparently there's one, but you say you got 2 from the prosecutor?
Yeah, there were 2 on the email from last night, and then I think he sent one the day before, maybe that had 3. So I want to make sure we get the right ones on here.
Right.
That is no problem. I'm sending that right now. CCing.
But she doesn't know which of the 2 that were on yesterday are supposed to go.
Right. It's the one so I sent 2 last night. That's Miss Bell's call in 2 parts.
Oh, so, okay. So both of them from last night are the second call and those go in.
Okay.
And then he's sending you the one from today also that is exhibit number 8.
So last night and this morning, I sent different, because I think there was an issue with playing the spliced call, which is 2 files. So I think that's the confusion.
Yes, I have the 2.
You have those 2 files, Dawn. I'm going to send you a 3rd file, which is the entirety of Miss Sales' call to 911 from the gas
Okay,
station.
perfect.
And then you're gonna take a laptop in there?
Yes.
Okay, thank you.
You bet.
All right, so Mr. Bratt, where are you gonna be while the jury's deliberating?
I'll be back to my office.
And where's Miss Sale gonna be?
Mostly right around here. Sorry, right around here.
You're gonna stay at the courthouse?
Yeah, I think I'm gonna go get something to drink and I'll be back.
Okay. And where are you gonna be?
I'll be in my office.
Which one?
The Norm Dix.
Okay. Then we'll give you a call when we get a question or a verdict.
Very good. Thank you, Your Honor.
Thank you. We'll be off the record. And we can go off YouTube. Now, what about your 10 o'clock matters?
I'm running over there right now.
To quorum 2?
Yeah.
Okay. And then I have 2 things on at 10:30, I think.
Yeah, I think both of them were dismissed, but they're.
Okay, you can go.
nominations.
Where am I gonna hear the 10:30 comment?
I didn't know you had one.
Yeah, Heidner and Terrell.
I don't know. I was unaware, so I didn't figure that out ahead of time.
Well, is there a Zoom? If I zoom in here, can I just get on that call?
Yeah.
Yeah, I'll do that at 10:30.
I'll let them know.
Huh?
I'll let people know.
Your Honor, are you ready for me to stop recording and turn off the live stream in this meeting?